The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
I am just inspired by the next generation. I think it's a time for a big change.
In light of the most recent Fifth Circuit ruling, the ATF's pistol brace rule is currently subject to a federal injunction. New rules for addressing stabilizing braces. The final version of the stabilizing braces rule has been published in the Federal Register by the Department of Justice. This rule stipulates that all parties involved in the production, sale, and possession of short-barreled rifles, including manufacturers, dealers, and private persons, must comply with the laws that govern the use of such weapons, including the National Firearms Act. The rule's goals are to protect communities from the dangers posed by gun violence and to stop individuals from getting around regulations that were enacted almost a century ago. Because short-barreled rifles are more easily concealed than long-barreled rifles, yet have more destructive potential than standard handguns, the NFA has put limits on short-barreled rifles since the 1930s. This is due to the fact that short-barreled rifles have shorter barrels.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
As many of you out there, either parents, relatives, and/or victims yourself.
The regulation gives manufacturers, dealers, and private persons a period of 120 days, during which they can register tax-free any existing NFA short-barreled rifles that are covered by the rule. Taking the firearm back to its original form as a pistol by removing the stabilizing brace or turning over covered short-barreled rifles to the ATF are two other alternatives. The notice of proposed regulation was published by the Department of Justice on June 7, 2021. Over 237,000 comments were sent to the ATF during the open comment period that lasted for the subsequent 90 days. Pistol brace limits temporarily blocked by federal appeals court. A federal appeals court has temporarily prevented the Biden administration from fully implementing new limits on pistols with stabilizing braces. These are gun accessories that President Biden has deemed especially dangerous after they were used in previous mass slayings. The court's decision comes as a result of the administration's petition to the Supreme Court of the U.S. The Fifth Circuit Court of Appeals enjoined the Bureau of Alcohol, Tobacco, Firearms, and Explosives from enforcing its new rule against gun owners and Second Amendment groups that filed a lawsuit contesting the regulation. A few days before the deadline set by the ATF for persons to register their pistol braces with the agency, destroy them, or remove the accessories from their firearms, the interim injunction was issued. Those individuals who do not comply with the regulation by the due date of May 31 will be subject to a fine. According to the ATF, those who choose to keep their handgun despite the fact that it is fitted with a stabilizing brace face the possibility of up to 10 years in jail, a fine of up to $10,000, or both of these penalties. The stabilizing brace rule requires millions of gun owners to register their firearms, which gun rights groups claim is a violation of the Constitution and has been challenged in court by those groups. One of the plaintiffs in this action, the Firearms Policy Coalition, has referred to the regulation as onerous and unconstitutional.
Yes, good faith applications of Bruin will likely result in some favored gun control laws being struck down.
Started just like, wow, it doesn't fit the definition, it doesn't fit the rulings, but we better run this up the chain.
To the extent that Bruin threatens certain laws, however, these are generally laws that weren't very good at protecting the public in the first place.
The FPC appealed a lower court judgment from a judge in Texas who had declined to halt the enforcement of the rule while the challenge was being heard in court. As a result, the issue was brought before the Fifth Circuit Court of Appeals. As part of the comprehensive gun crime policy that Biden presented in April 2021, the stabilizing brace regulation was developed as a direct response to the mass slaying that took place at a grocery store in Boulder, Colorado, in which the perpetrator killed 10 people with a rifle that was modified with a stabilizing brace. In 2019, a shooter in Dayton, Ohio, who was responsible for the slaying of 9 individuals, employed a stabilizing brace over the course of the attack. According to the ATF's definition, a stabilizing brace is a device that provides a surface area that allows the weapon to be fired from the shoulder, as long as other factors that indicate that the firearm was designed, made, and intended to be fired from the shoulder. The rule, which was completed by the ATF on January 13, classifies handguns with attached stabilizing braces as short-barreled rifles. Short-barreled rifles are subject to stringent regulation by Congress due to the fact that they are both accurate and concealable, which makes them potentially hazardous in the wrong hands. Biden has leveled the accusation that the firearms industry is attempting to evade federal rules through the sale of stabilizing braces, which he and his administration assert essentially convert a pistol into a short-barreled rifle. According to the ATF, there are at least 3 million firearms in circulation in the U.S. that are fitted with stabilizing braces. According to the findings of the Congressional Research Services Survey, the number of stabilizing braces that are now in use ranges anywhere from 10 million to 40 million.
That requirement for showing a heightened need for self-defense, that was the teeth of these permitting laws.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
American citizens in places like New Orleans and Baltimore and St. Louis begin to seek asylum in countries like Honduras and Guatemala.
I don't know if you're referring to any particular incident.
Stabilizing braces have been mischaracterized by the government, according to proponents of the Second Amendment, who point out that these devices were developed to assist handicapped combat veterans in continuing to participate in leisure shooting. They have also contended that an earlier judgment by the ATF stated that the attachment of a stabilizing brace to a handgun does not convert the pistol into a long gun. This ruling was made 10 years ago. The judgment made by the court did not instantly make its full repercussions obvious. Only the plaintiffs in the case were required to comply with the decision, which included 2 gun owners, a company that manufactures pistols with stabilizing braces, and a gun rights group. The appeals court did not indicate whether or not the regulation was barred for others, such as customers of Maxim Defense Industries or members of the Firearms Policy Coalition. The court did not mention whether or not the rule was prohibited for others. In a statement, FPC stated that the organization is requesting clarification over who exactly is included within the scope of the injunction. "We are very excited and encouraged by the Fifth Circuit's decision this morning," said Cody J. Wisniewski, senior attorney for constitutional litigation for FPC Action Foundation. "We intend to ask the court for additional information about who is covered under the injunction. However, we cannot overstate how important it is that this decision be made. This is a tremendous victory in the struggle against the ATF's illegal and unlawful brace rule. The fight is far from finished, but this is a huge victory in the campaign." Federal appeals court deems ATF's pistol brace rule likely illegal. A federal appeals court declared that a law in the U.S. that restricts possession of gun modifications, known as pistol braces, is likely illegal. This was a victory for a gun rights group that had been fighting the rule. The United States Bureau of Alcohol, Tobacco, Firearms, and Explosives approved the regulation in January without providing the public with a meaningful opportunity to comment on it, according to a decision reached by a panel of the 5th U.S. Circuit Court of Appeals, which has its headquarters in New Orleans. The panel determined that because of this, it violated the Administrative Procedure Act, which is a federal law. The lawsuit was remanded to U.S. District Judge Reed O'Connor in Fort Worth, Texas, rather than the immediate injunction on the rule's implementation as was requested by the plaintiffs. O'Connor will be tasked with deciding whether or not to issue an order prohibiting enforcement while the case is pending, and if she does, she will have to determine whether or not that injunction will extend to the entire country or whether it will merely apply to the plaintiffs in the case. A number of federal judges have already granted preliminary rulings that halt the enforcement of the rule that was imposed by the administration of President Joe Biden, but is being challenged in court by gun rights organizations. However, these orders only apply within the jurisdictions of those judges and only to members of the respective organizations.
June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
Most apparent here a defense of the Second Amendment, which this most certainly is.
Weim says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
The Firearms Policy Coalition is the party that initiated the legal action. The lawyer for the organization, Cody Wisniewski, referred to the decision as a huge win for peaceable gun owners across the nation. Both the ATF and the Department of Justice refused to comment on the matter. In 2012, pistol braces were introduced to the market for the first time as a method of securing a pistol to the shooter's forearm in order to stabilize it and make it simpler to use for people with disabilities. However, several users discovered that the braces could also be worn on the shoulder, similar to how the stock of a rifle is held in place. The contentious rule stipulates that certain firearms fitted with pistol braces must be categorized as short-barrel rifles. This determination is made on the basis of many criteria, including the firearm's dimensions and weights, as well as the marketing materials provided by the makers. Because of their potentially greater lethality compared to handguns, short-barreled rifles are subject to additional regulations such as special registration, extended waiting periods before they may be purchased, and higher taxes. Judge Jerry Smith of the Fifth Circuit ruled on Tuesday that the final rule issued by the ATF was drastically different from the draft rule that the agency presented to the public for comment in 2021. The judge referred to this as pulling the rug out from under the public. In a separate but concurring opinion, Circuit Judge Don Willett stated that the rule most certainly violated not just the Administrative Procedure Act, but also the right to keep and bear arms, which is protected by the Second Amendment of the Constitution. The majority of the court chose not to examine this particular issue. In his dissenting opinion, Circuit Judge Stephen Higginson argued that the final rule did not need to be subject to public comment because all it did was interpret a statute that had been passed by Congress. Higginson was appointed by Democratic former President Barack Obama, while Republican former Presidents Ronald Reagan and Donald Trump were responsible for appointing Smith and Willett to their respective positions. Update on ATF pistol brace case and recent developments. Let us supply you with the most recent information regarding the ATF pistol brace case that is currently being heard in a lower court. In case you don't remember, let us remind you that there was a new development in the judicial processes just recently. A decision that was handed down by the Fifth Circuit Court of Appeals not long ago has major repercussions for the ongoing investigation into the ATF pistol brace case. In the case known as Fifth Circuit Court of Appeals versus ATS pistol brace rule, the Fifth Circuit Court of Appeals came to the conclusion that the ATF pistol brace rule should be overturned. This decision was made as a result of the case known as Mock v. Garland, in which the Fifth Circuit Court of Appeals found that the district court had made an error when it initially denied the plaintiff's application for a preliminary injunction. As a direct consequence of the ruling made by the Fifth Circuit, the matter was remanded to the lower court, where it is currently being presided over by Judge Reed O'Connor. The direction that was issued by the Fifth Circuit to Judge O'Connor was for her to produce a fresh judgment about the injunction within the following 60 days. This new information is a huge win for the pro-toy camp and points to a potential turning point in the argument against the ATF's existing restriction on pistol braces. The plaintiffs in the case have responded to this remand by submitting a supplemental brief that addresses the remaining factors affecting the injunction. They are making a concerted effort to argue their case in front of Judge O'Connor. In addition, the plaintiffs are looking to take a big legal step by asking Judge O'Connor to issue an injunction that applies to the entire country.
I don't really see the purpose of letting other people that don't really know what harm they can do.
You specifically said that.
But I said...
What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice?
I would expect to see in the coming months and years is a lot of focus on whether or not enough places are deemed sensitive right now.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
By taking this action, they have demonstrated their determination to challenge the ATF's position on pistol braces. The plaintiff's motion for a preliminary injunction was turned down by the federal district court that was presided over the initial Mock v. Garland case. The judge who presided over that court was Reed O'Connor. In his ruling, Judge O'Connor ruled that the plaintiffs had not fulfilled the burden of proving a considerable likelihood of success on the merits of their claims. He said this because the plaintiffs had failed to demonstrate a substantial likelihood of success. As a direct consequence of this, the application for preliminary injunctive relief was turned down, and the alternative request to postpone the date the final rule goes into effect was also turned down. The recent developments in this case, in especially the ruling handed down by the Fifth Circuit and the subsequent remand to the lower court, have prepared the groundwork for crucial legal actions that have the potential to transform the regulatory landscape pertaining to ATF pistol braces. The fact that the plaintiffs are trying to get a countrywide injunction emphasizes both the importance of this issue and the potential impact it could have. Fifth Circuit review and decision on ATF pistol brace case. A subsequent sequence of circumstances resulted in the case being examined by the Fifth Circuit Court of Appeals. This review procedure was rushed, and it culminated in a conclusion that carried significant repercussions for the future. The key to determining the outcome of this review was mostly dependent on whether or not the plaintiffs were eligible for an injunction under the Administrative Procedure Act. The Firearm Coalition filed an interlocutory appeal with the Fifth Circuit Court of Appeals after their request for an injunction was initially denied by the lower court. The purpose of this appeal was to question whether or not Judge O'Connor erred in her judgment to reject the request for an injunction by exercising her authority inappropriately. The Fifth Circuit did extensive research to get to the bottom of the issue. The evaluation made by the Fifth Circuit centered on the plaintiff's contention that the final rule breached both the procedural and substantive requirements of the APA. In this scenario, the plaintiffs were successful in establishing a significant likelihood of winning their case based on the merits of their argument. The ATF's claim that the final regulation was more interpretive than legislative was debunked by the findings of the investigation. According to the logical outgrowth test, the legislative intent of the final rule was made clear when it significantly impacted private interests and individual rights with the force of the law. The fact that the final rule was nearly unrecognizable from the rule that had been initially drafted was a crucial factor. The Fifth Circuit determined that this departure was substantial, which led to a failure to satisfy the logical outgrowth test and, as a consequence, a violation of the APA. Another oversight that was brought to light was connected to the Worksheet 49.99 that was included in the proposed rule. This worksheet included well-defined point systems and requirements, yet the final rule did not at all include any of these elements. This omission was deemed a violation of the APA by the Fifth Circuit Court of Appeals due to the fact that it did not comply with the logical outgrowth rule. One of the most important questions that arose was the following: why did the Fifth Circuit Court of Appeals decide against the ATF's contention that the pistol brace rule was interpretive rather than legislative?
Because they like the outcome of the policy, the banning of a piece of plastic.
Post-Bruin challenges have succeeded in lower courts. The opinions and reasonings therein have been grossly mischaracterized.
According to the opinion of the Fifth Circuit, the profound impact of the regulation demonstrated the legislative intent, which went beyond mere interpretation. The ruling handed down by the Fifth Circuit also shed some insight on the initial rejection of the preliminary injunction by Judge O'Connor. It came to the conclusion that the decision made by Judge O'Connor to refuse the injunction was incorrect. In addition, the crucial element of this decision was the Fifth Circuit's admission that the plaintiffs had satisfied the most difficult condition for obtaining an injunction. This admission was the reason why this ruling was so important. This included proving that there was a likelihood of success based on the merits, that there was irreparable injury, that there was a balance between the evils, and that the public was interested. The complicated legal proceedings surrounding the ATF pistol brace case have seen a number of developments during the course of the investigation. The examination conducted by the Fifth Circuit not only indicated that there were violations of the APA, but it also highlighted the strong cause that the plaintiffs have for obtaining the requested injunction. Probability of success and nationwide injunction. Establishing a reasonable possibility of success on the merits in a variety of legal matters frequently paves the way for getting an injunction, and in many instances, it can also result in a good outcome for the case as a whole. This is because a reasonable probability of success on the merits indicates that the plaintiff is likely to prevail in the case. In the context of the lawsuit involving the ATF pistol brace, the opinion handed down by the Fifth Circuit accepted that the plaintiffs had actually proven a substantial chance of success on the merits of the case. As a consequence of this, the matter was sent back to Judge O'Connor with instructions to have him reconsider the injunction. The re-examination that Judge O'Connor is going to conduct, on the other hand, will zero in solely on the remaining issues that are relevant to the injunction. The plaintiffs have most recently provided Judge O'Connor with a supplemental brief in answer to her questions. In this pleading, they argue that they have satisfied all of the remaining requirements for an injunction and that it should therefore be granted to them. In addition, they support the idea of the government issuing a countrywide injunction to block the implementation of the pistol brace requirement. The plaintiff's brief emphasizes the Fifth Circuit's decision that the plaintiffs have a significant possibility of success in their claim that the final rule violates the APA. The Fifth Circuit came to this conclusion after reviewing the plaintiff's argument that the final rule violates the APA.
We are not finished. We are not finished. We are not finished.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Not one more! Not one more! Not one more!
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
They believe that the likelihood of success on the merit is the most important consideration in the preliminary injunction, and that this factor strongly favors the plaintiffs by virtue of the fact that it is the most important factor. The plaintiffs argue that when the other elements are taken into account, the scale clearly tips in their favor and should be given more weight. They argue that the harm done to them is more significant than any hypothetical damage that could be done to the government. They argue that an injunction would do nothing more than preserve the long-standing status quo that prevailed in the years leading up to the ATF's implementation of their new pistol brace rule. The plaintiffs argue that Judge O'Connor should not place any limitations on the type of relief that is awarded to them. They instead support the implementation of a countrywide injunction. Even if the court does not agree to issue a national injunction, they believe that it should, at the very least, mirror the extent that was granted by the Fifth Circuit. This would protect individual plaintiffs in addition to members and memberships of organizations such as FPCs. In a note of conclusion, the plaintiffs stress the necessity of a worldwide injunction that prevents the defendant from applying the final rule. They argue that the current circumstances call for this type of injunction. The Administrative Procedures Act upon which this dispute is predicated provides the essential groundwork for this argument. The possibility of getting an injunction and the possible implications of its breadth continue to be central issues of contention in the ATF pistol brace case as the legal proceedings progress. The allegations and arguments put forth by the plaintiffs provide light on the complexities of the problem, as well as the continued attempts being made to find a resolution that is satisfactory. Court's authority and scope of injunction. This court has the clear statutory jurisdiction to issue any and all processes necessary and appropriate to safeguard the status or rights while the review procedures are being carried out. It is essential, before the publication of the final rule, to enjoin it in order to keep things as they have been, in order to protect parties from the harms that will be caused by the final rule. Prior to the publication of the final rule, the plaintiff Maximum Defense Sales had already been selling brace pistols and stabilizing braces over the entirety of the U.S. Because the final regulation will have such a pervasive influence across the whole commercial chain, the disruption it has caused will continue unless the final rule is generally enjoined across the country. The plaintiffs contend that the breadth of the injunction should, at the very least, be comparable to that which was established by the Fifth Circuit. Individual plaintiffs, their families, Maximum Defense, its clients, direct consumer purchasers, intermediates such as distributors and dealers, and every business along the supply chain were all protected by the injunction issued by the Fifth Circuit. They highlight the fact that all active members of the Firearm Coalition should be safeguarded from harm. In the ongoing action between the ATF and the pistol brace manufacturer, one of the hotly debated topics is whether or not all members of the FBC should be protected. The previous opinion of the Fifth Circuit Court of Appeals has already given the plaintiffs permission to proceed with the most difficult part of the injunction test.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Field background checks could stop a lot of illegal guns going in different places in the country.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
As a consequence of this, Judge O'Connor's current deliberation is exclusively centered on the remaining aspects of the case that will determine the breadth of the injunction. For the purpose of deciding whether or not to issue an injunction in the V. Garland case, Judge O'Connor has been given a period of 60 days, starting from the date the order was issued by the Fifth Circuit. Organizations such as FBC Goa SEF and others continue to operate within a system that is analogous to the previous one, and this ensures that members continue to receive coverage. The continued pursuit has as its goal not just the preservation of this coverage, but also the expansion of the injunction's remit. The end goal is to secure an injunction that applies across the entire country. Because it is up to the judge to decide how far-reaching the injunction is, the outcome of the case is currently dependent on the judgment that is about to be handed down by him. The evolving actions that are taking place within the ATF pistol brace case continue to be fluid as time passes. The determination of the plaintiffs to defend their interests and contest the implications of the ATF's pistol brace rule is shown in their dogged pursuit of a broader injunction, which the plaintiffs are pushing for. It is possible that the upcoming ruling by Judge O'Connor will determine the direction that the litigation will take moving forward. That's all for this video, folks. See you next time.